Good morning. And another alarming judgment. It will be most important for young lawyers, social workers, social interested advocates, and particularly the doctors. See, it is very shocking. However, first let me discuss about the judgment. AR 2024 Supreme Court 945. AR 2024 Supreme Court 945. Palani versus Tamil Nadu State. In this case, a doctor running a clinic, there was some inspection. At that time, there are about 29 kinds of drugs were seized. The doctor not in a position to disclose the manufacturer or the sources from where these drugs were obtained. Therefore, the doctor was charged and tried by additional district and session judge Tiruvallur. The doctor was convicted under section 18C read with section 27 of the Drugs and Cosmetics Act and 18A read with section 28 of the said Act. The difference between 18C and 18A is, if 18C says that you are intent for sale, 18A that you are not in a position to disclose the source of the medicines. I understand it correctly. Whatever it may be, that is not important. You go through the case and understand the case. There was a fine of rupees 1 lakh and he was under 3 months sentence. And under section 18A, 6 months and a simple imprisonment, a fine of 20,000. And also it is also very important that 2,500 cost for publication under section 35 of the said Act. Finally, the Supreme Court has set aside the conviction under section 18C. But he was convicted for other offence 18A, wherein they say since he is a doctor and there is no evidence that he was storing the drugs for sale. Therefore, 3 months sentence was set aside. 10 lakhs was cost imposed to the doctor. Whatever it may be, I humbly request my young lawyers, this provision should be this Dangerous and Drugs Act, Drugs and Cosmetics Act is one of the scheduled act, and Jan Viswas Act, which was recently passed, decriminalization. So kindly check with that Jan Viswas Act whether this provision 18A, 28, 18C are listed for compounding the offence or payment of fine, whatever it may be. But the fines are very exorbitant. So normally drug inspector, being a public servant, his complaint is being inquired into under section 200 CRPC. But proof of affidavit not necessary because he is a public servant. That is 19B. These things you should understand and go through very short judgment. And the Mohammed Ghiyasuddin case was discussed. Mohammed Ghiyasuddin case. This case was AR 1977, SC 1926. So since this is a case of 2019, probably that act, Jan Viswas Act, was not referred here. So hereinafter you be careful there are multi number of acts were listed for decriminalization. Jan Viswas Act. I hope you understand. But what was shocking me, if that manufacturer of drugs was not disclosed, what does it mean? That means some forged duplicate drugs are being stored. Stored for what? Court says it was not for sale because there was no evidence. I will stop here. Let us hope something better judgments by the Supreme Court when they expect the trial courts for participatory trial. Here the court would have concerned about the storage of drugs. Ultimately sufferers are innocent poor people, because this doctor is running a small clinic at Pallipattu near Arakkon. Rest